However, there can be an exception. Suppose even if you don't even have that kind of a thing. So now what? You don't have an email, you just had phone conversation with the seller, and you have nothing, and now you are asking the seller to perform. There is one exception in purchase of real estate. If you do part performance of your agreement, then you have an enforceable agreement even without, if you don't have any kind of writing. It's just based on mere conduct of the parties, kind of a situation. So suppose, for example, and it's a real case, a tenant want to also get into a lease and want to have a purchase option in future, and that tenant has came to an agreement that, suppose I will be buying this property for 300,000 within 3 years, and I will be paying you down payment now, and whatever payment for rent I would be paying, that you should consider as the mortgage. And that's the oral agreement happened between the landlord and the tenant. And the tenant, once moved into this property, had paid substantial down payment, suppose, for example, 20%. And then the tenant was keep on paying the payment, which was supposedly seems to be a mortgage payment, which they have agreed on. And after 2 years, the buyer now asking for sale of this property on his name, and he has sent the notice to the landlord that I am willing and I am ready to exercise my option. However, now the landlord is saying, oh, I think we don't have an agreement, and I am selling this property to someone else who is paying me a lot. And now what should happen? Means even under like mere language of civil code, the buyer is not covered, unfortunately, because this landlord didn't have any writing or have any indication in writing that he is selling on these particular terms this property to the tenant. So what should the tenant do? And after extensive case law, this is the situation which is really the courts have developed or interpreted for the statute of fraud, and one of the exception that if you are doing part performance of your supposedly agreement, then you should have the right to this property. And that's also, I think, also seems logical and also fair, even if you don't have a writing. So at the end, the court have seen, okay, this tenant has made substantial down payment. He has given the money to the other side. Why he should just give money to a landlord, supposedly $30,000 to $40,000? Why he would be giving that money? And why he would be giving the payment which seems to be in the same amount as of the mortgage payment? And he have been making that payment from long time. So, and also this tenant had made substantial improvements on this property and have been paying taxes on this property. So the court, through this circumstantial evidence, have saw the situation that it would be unfair to not allow the tenant to buy this property on this oral option agreement now, because tenant has performed, and we can see from this that whatever the tenant was saying seems to be right, that they had agreement, but just for this technicality of not having something in writing, we would not allow the landlord to just walk away and have an unfair situation with this tenant. So the law, even the law if sets a technicality, it just provides a logical way to get title of the property. So the main purpose with that technicality of having that thing in writing from the party you need performance, it's just basically to make sure that the people are taking the purchase or sale of real estate seriously, and they are doing that thing in writing. And the last topic I want to talk about is the electronic signatures, because some people have concerns, and still now, that the electronic signature maybe have some issue, maybe they are not enforceable, maybe the other side, suppose the seller can say, okay, means it's just bunch of typing which happened, this is not like real signature with your wet ink, so this agreement should not be, because this is somewhat new, because in real estate anything which comes under decade, it seems to be new, because real estate laws moves really very slow compared to the other laws. So this seems to be like a recent thing happening, but however it's catching up. So the authority which the civil code provides, and it codifies in civil code the Uniform Electronic Transaction Act, which is California adopted law from uniform set of laws. And also the federal law, we have E-Sign Act, which is codified under United States codes. So from these two laws, this provide complete enforcement to any kind of agreement, including real estate agreement, if that agreement was signed through some framework of e-signing. And I think most of my realtors friend use DocuSign or some electronic form of zip forms, and so those are legal because you can track them, because they have really very good form of auditing and providing a trail of what activity happened. An email was sent to the buyer and then buyer signed, it generates and provides a unique ID for that. And there is also different other authentication processes you can use to make it more stringent if you just get afraid about it. But any kind of electronic signing, even if you send a PDF document to the other side and the other side types its name and send you back that document, again you have to apply that reasonable person standard. A reasonable person would think that this person has typed the name and it's basically an electronic sign, and I should rely on it, that this person is saying to me that I accept your offer or I present you this offer, and we should just move forward based on the conduct of the party. So any kind of real estate agreement, basically purchase agreement, you are e-signing, those are enforceable. Sure, generally you have to look other situation, other facts which may surround your particular case, because there can be a situation where parties are on the sides saying something different about it, or even after signing there is some change of agreement. So generally the e-signs are sufficient enough to bind any party on a particular agreement. However, there can be a situation where there are certain type of agreements which are not included in these codified laws yet. And these agreements are your landlord-tenant lease agreements, your seller financing disclosure, your home equity loan agreement, and also the agreement for verification of your electronic signature, because you need a wet signature to authorize an electronic signature. If there needs to be a verification about that, you obviously need that. So these are few of the agreements which are still excluded in this law. But sure, I think in future, as we are, I think, moving forward in the electronic age, I think I am confident that all these agreements would become under this existing laws, and these agreements would be also acceptable through an electronic form of signature. And there is last important recent law which have been codified in 2015, that if you send any kind of, because we were talking about if someone sends you an email and you have this terms and agreement, and then you can ask that person to perform the agreement, and you have this binding agreement generally. However, this recent 2015 statute, it provides under civil code that if you are sending or asking for enforcement of any agreement which was created through a temporary form of messaging, because there are temporary form of messaging, you can create an email which will expire within like 6 hours. You can do that now, or you are expiring within 24 hours, so it's gone. So any kind of temporary messaging thing which would not be remaining permanent electronically, if you are trying to enforce through that medium any kind of agreement, so that's generally would not be acceptable and would not be enforceable. Sure, it's a recent statute, so the court would be interpreting that statute. It's somewhat vague, but still it just provides you a heads up on that. It's always, I think, good to have a formal agreement instead of having this ongoing emails or text messages informally and just messing up the whole situation. Because you are dealing with real estate. Now real estate is expensive, and also real estate is always at that amount which is significant enough in your life. So you should have a formal agreement, I think, most of the time. So this provides you basic points about a purchase agreement and the process about it. So in next video, I would be talking about, once you are now in this purchase agreement, so how you move forward, about different conditions, what are the duties of parties, and about your due diligence, and about various other things which may go wrong in your transaction, and you should just at least keep an eye on those things. And again, just work hard, and if you have any legal worries, let us know. We can review your agreement or negotiate on your behalf in any kind of commercial real estate purchase, and any kind of issues you are having even after your purchase. So thanks for watching these videos, and I will look forward for your you're eyeing these videos again in future for getting some general legal information and helping maybe your business operation in future. Thank you.